Hi again, my name is Taylor Kaufman.
And I'm Alejandra Moreno.
And this is the Wake Podcast. So, on our last episode, we spoke about a will versus no will. Right. And we discussed how, with either a will or no will, you still need to go through probate court. Right. And I guess now we're going to talk about a will versus a trust, right?
Yeah, so there are a lot of options for avoiding probate. Mm-hmm. A trust is just one option, but it's a great option because it's very customizable. So what is a trust? I guess let's be more specific. A revocable living trust. A revocable living trust functions much like a corporation in the sense that anything in the name of the trust or beneficiary to the trust is controlled by the trust and completely avoids probate. Now, when you create your trust, you are usually, not always, but you are usually the trustee. Mm-hmm. So you maintain ownership of all of the assets in the trust. And then once you pass away, you have a successor trustee, which is basically just a successor administrator once you're not there. And one of the beauties of a trust, not only does it avoid probate, is so personalized. It's so customizable. Instead of, like in a will, when you go through probate, at the end of the case, everybody gets their checks, their property, whatever, and it's done. In a trust, you can say, I want my kids to receive a monthly amount, a yearly amount, a percentage of the trust. I want my one son, he can't receive his inheritance unless he goes to church on Sunday. I have a son with a substance abuse problem. I want to make sure that the inheritance doesn't go to his substance abuse. So you can almost continue to take care of your family, to raise your kids after you're gone.
Right.
On top of that, in probate cases, and we'll talk about this in detail in another episode, in probate cases, if there's a minor beneficiary in an estate, their inheritance now is going to go into a guardianship, another court process, mm-hmm. and that's going to sit there until they turn 18, and when they turn 18, they get all that money, and it's over.
Yes.
In a trust, even if it's a minor, you can still benefit the minor without distributing to them, and it completely avoids a guardianship as well. Mm-hmm. So it's a great way to keep your, family information private. It's a great way to make sure that you're not just giving a lump sum out there. So I think it's a beautiful vehicle. I have a trust. It's excellent. And I know I talk really fast, especially when I'm explaining trust. So if you need to translate,
You're passionate.
Please, please feel free to translate.
So I just want to, what you just said, like a trust completely avoids probate, right?
Yes, if it functions properly. So we have seen clients that have their trust signed, all, their wishes are perfectly stated in blue ink. It was mm-hmm. signed correctly, all that jazz, and there's nothing in it. Which means they're going to be going to probate to transfer everything to the trust. Not them, but their heirs. So yeah, that's what I was saying, that it's kind of functions like a corporation. It's got to be in the trust. But yes, you're right. Let's go through that. What does it mean to transfer your assets to the trust mm-hmm. or place them in the trust or beneficiary to the trust? Why don't you talk a little bit about that?
Right. So like you said, it kind of functions like a company. So you want to make sure that all of your assets are in the name of the company, and in this case, in the name of the trust. There's kind of two ways of doing it. It depends on what asset you're transferring. So the most common are like bank accounts, properties, companies, things like that. So for a bank account, what you would do is once a trust is set up, meaning once a trust is signed and you have a full name of the trust, you would go to the bank, or a lot of times you can download a form online, and you would either add the trust as a beneficiary. So if you add the trust as a beneficiary in the account, when you pass away, the trust becomes the owner, or you can change the account name on the bank account.
Right, but if you change the account name, and you have your electricity bill, your mortgage, everything on auto pay, if you change the account to the trust name, now you need a new account number, mm-hmm. everything. It seems like a lot more work.
It does.
You're already going through the work of putting everything in your trust. So I think that's a great idea. If you put the trust as beneficiary, it automatically, is owned by the trust upon death. So that's a great tip.
Yes.
Okay.
And, these are tips, obviously, we give our clients. Like, once they sign, we don't just like, okay, you sign your documents, like, fund your trust on your own. We walk them through the process, and we give them these little tips and tricks along the way.
Well, and that's a great point, especially people that, I had this real estate attorney when I bought my house, and they were awesome. And I asked them, I like them so much. Can you do my trust? And they did our trust. And we're like, okay, that's cool. The trust is fine.
Mm-hmm.
Maybe it's just like a boilerplate. They just changed the names and the dates, and not great, but okay. So, is your trust funded? What do you mean? It's that's a very good point.
Yeah. And then we've seen people with a trust, and very fancy. They go to a big law firm and they get the trust done, and that's
Also
it.
not
Once they
funded.
sign, they give them a copy, and like they're out the door, and they don't follow up with them. And I think that's really what sets us apart, you know, in ASN Law Group, because we follow up with our clients, and we're like, you know, a lot of times we know people, and it's a community. Like you said, Miami is very small, but we also want to make sure that we're putting out a good work product, and our clients are getting, you know, what they're paying for.
And you know, the name is a revocable living trust, which means that it continues to live on even when you're, you know, passed away. But it's revocable while you're alive. Once you pass away, you can make no changes. While you're alive, you can make all the changes you want.
Yeah.
Right. And I think that's the reason why we make sure that our clients, at least once a year, are aware of any changes in the law. We want to remind them, you know, do you have a new baby? Do you have a new grandbaby? Is there somebody you want to include? So we make sure that you're always benefiting the people you want to benefit,
Right.
and your true wishes are expressed. And I agree. We make a huge effort on the back end to make sure that what we explained to you, what we told you this trust can do, it's gonna do.
Yeah.
We
Yeah.
don't want to just send you off into the wilderness to figure it out. We want to make sure we're walking you through it, and we want to, you know, fulfill our promise to you.
Of course,
right?
yeah. And really make it, I mean, you mentioned on this, and I know we're getting into like how to fund your trust, but you mentioned something earlier, like you can customize this document and make any distribution you want, you know, making sure you're, you know, whoever goes to church or whatever. And I have to ask, because you've been practicing for a long time, like, what is the craziest distribution request that you've
I think I mentioned that one, you know, because that was one of the like really specific ones that I was like, okay, yeah, I mean, that's great. If that's what you believe in and that's what you want to instill in your kids, I think that's great. We did have a case of a person who their kid had been struggling with substance abuse for a very long time. And, you know, when I've never even created a trust like this. Like, it went so far into the details of how this parent wanted to help their child and how this parent wanted to make sure that all of the resources were specifically detailed in the document. You know, they weren't just like, you know, stick them in a rehab and let them fit. No, it was like there were so many people involved in helping this person like stay in recovery.
That's nice.
And it you know, it made me feel great because it's like this, you can tell this parent was struggling with the substance abuse,
Yeah.
just seeing their child dealing with it. And it made me feel so good. He actually passed away, I think less than a year after we created the trust.
wow.
And of course it was sad. He was a great person, but it made me feel like, you know, he's in peace.
Yes.
That he did everything possible to make sure his kid was taken care of.
Yeah.
And, you know, things like that, they
nice
kind of make
story.
me feel like, you know, that was worth it.
Yeah.
But it took weeks for us to get this draft together, and it was exactly what he wanted.
That's awesome.
And that made me feel so good. And you know what? He wouldn't have been able to accomplish that doing a LegalZoom trust.
Of course, yeah.
It would not have been the same. And there were things that he was adamant about wanting in there. And I'm like, look, that's just not, it's not going to work. It's not going to function the way you want. And I'd give him an alternative. He's like, yes, okay, that's perfect.
That's awesome, yeah.
And those are little things that you're not going to get unless you're with somebody who focuses on this field of law, right? But I think those might be, there's another one that we actually talk about often. You know, I always say, like, we love our in-laws until we don't. Right. So, oh, my kid got married and, you know, I love my in-law. I love them so much. And then down the road, something happens and you're like, oh, things are kind of rocky. And then you start thinking like, well, if I pass away and my kid gets my inheritance and their marriage is on the rocks, now it's going to be subject to divorce. So, you know, there are little things that we can implement in our documents to help put your mind at ease. Hopefully it never comes into play. Hopefully you never need it. But, you know, I think those are probably the weirdest, not weirdest, but the ones that stand out the most.
Yeah, they're really customizable. And that's what, you know, makes a difference, like you said, going to an attorney, and also just knowing that you have the option to do that. I feel like a lot of attorneys, or sometimes not even attorneys, but you just, if you don't know, you don't ask. And sometimes people don't tell you. So it's good to have that knowledge and to go forward with it. But
for sure.
All right, so getting back to funding a trust, like you said, it was the most
what else can we
important
put in this? You say that you put in a box?
Yeah, that's how I explain it. Like,
Okay.
you're putting all of your assets into a box, and the box is a trust, so that way
Right.
when you pass, everything in the box gets distributed out.
Okay, I like that.
And
I
then,
like
you
that.
know, it's very easy. So, like you said, you don't need to go through probate with a trust, and you also don't need to have an attorney involved, right? If the
Right.
trust is funded properly, so all your assets are in the trust, when you pass, all you would really need to do is have the trustee, so whoever is named in the document to administer the trust, someone you trust, they would go to the bank with a copy of the death certificate and the trust, and they would have access to that bank account, and they would just distribute it out
the way it says in the trust.
Exactly.
Yeah.
So, I mean, it's another plus of a trust. But.
Absolutely. So real estate, for example, your homestead, you don't lose any homestead exemption. You can transfer to the trust. Everything is protected. That's totally fine. Companies like LLCs and stuff, it's not often, especially if you open your own company. Most people don't get. Have you seen the Big Black Book? No, you haven't even seen this. Of course,
it's so young.
It's a lot of times when you open up a corporation, they send you the book that has, and it's a black binder, and it has the operating agreement, the articles of incorporation, and then it has stock certificates. I can't tell you how many times I've seen this book with the stock certificates empty. But people usually don't even order that book anymore. It's very antiquated, but I have seen them. So what do? If you own a company, an LLC, a corporation, but at the time that I pass away, I want to make sure, I've been building this business for 40 years. When I pass away, I have my trusted right-hand man that I want to, take over the company, or, my company has a lot of assets that are very, valuable. I want this person that I trust to appraise everything or to sell it at whatever the case may be. But I worked so hard for my business. I don't want it to just go through probate. Definitely not. And I also might not want my trustee dealing with this because, I work in something so specific, or, I have somebody that works with me, or I want my kids to become part of the business. I want them to, they work with, one son works with me. So I want to make sure that he can continue on that legacy.
Right.
I think that's great. So the shares, that come in that big black binder, that, we can create shares for you, because those shares are what it says, like, who's the owner of this company. So if this company has 100 shares, I'm 100% owner because I have all 100 shares. We can issue those shares to the trust, and now your business becomes part of your trust. And when you pass away, your trustee, along with whoever else you mentioned in your trust, can wind it down, can pass it on, can keep it functioning, can keep paying your employees.
Yeah, and that's a big thing. We've had cases, probate cases, where there's no succession planning at all. And the business, it's no one's running it for, months, and it kind of just falls apart and it goes, it's not worth anything anymore, which is unfortunate because people spend their whole lives, a small business owner, like, building up this business. And
we've had litigation cases where, we're fighting over this business and we're talking to opposing counsel, and they're like, that once the, the owner of the company dies, like, it's not worth anything. Well, because you have to go through probate, everything's at a standstill, you can't pay employee. Like, yes, oftentimes that's the case, but not always. Right. And if you've spent so long building a business, if you want to make it your legacy, it's totally possible, even if you pass away. There are so many ways that you can preserve this. But if it goes to probate, chances are, if you can't pay your employees for 6 months, if you can't, continue whatever projects you're on, if you can't continue the business, running the business, you can't make payroll, it's probably going to go under.
Yeah. No, of course. And that, it's a big thing with companies. I feel like, when you speak to someone about, like, funding their trust, they think, like, liquid assets, like a bank account or property, things like that. But, having these conversations, and I feel like we really do we do a very deep dive into our clients' lives. We ask them a bunch of questions, like, what assets do you have, everything, because it's important that, everything is held in the trust.
It's annoying. I know it's annoying, to really, like, think about what do you have, what do you don't have. But if you don't know what you have, you don't know what you have to put in the box.
Exactly.
Right?
Exactly, yeah.
So yes, I think businesses are a big one, especially, young entrepreneurs or people that have had a family business. You want to pass it down. I think definitely leaving instructions on how you want it done is a great way, especially if you don't want to hand over the reins while you're still alive. Right. You want to make sure that, and we've had clients that have lived to be very, very old, and I believe it's because they continued to work so long.
Yeah.
But that's a great point. It definitely is.
So, obviously, is it safe to say that anything that has a title or a beneficiary should be placed in your trust? I know that's a question we get asked a lot.
So, bank accounts, checking accounts, CDs, even investment accounts, real estate, LLC, and we said real estate, but even investment properties, it should be in a corporate structure to make sure that we preserve your trust. And I'll get into that in a minute, but I want to answer your question. Anything with a beneficiary. So retirement accounts, 401ks, IRAs, annuities, retirement accounts, if you have a spouse, you're going to want to put it in your spouse's name first, and then the contingent or the secondary beneficiary to your trust. Why? Spouses have a certain tax benefit for inheriting a retirement account. But if both spouses are deceased, then those taxes are going to be payable anyway. So you might as well add the secondary beneficiary as your trust, and then that will also avoid probate. But I think that's the right way to do it. For retirements, annuities, IRAs, like all of those should be spouse to spouse if you have it first, and then the secondary to the trust.
Right. And, that's a good tip that a lot of people may not know, but getting the full picture and, seeing if there's a spouse, what kind of assets you have, it really allows us to not only create a document that fits, someone's life and is tailored to them, but also to set up their assets in a way and place it into a trust strategically to avoid some, taxes and make it more cost effective. So.
For sure. And that's something that you probably wouldn't know to do unless you were guided, right? You're not really going to know. Or, you might say, I'm not going to transfer, my bank accounts because I already have a beneficiary on there. But you're thinking it's going to be distributed the way your trust says.
Right.
Like, no, that's going to that beneficiary. If it's not in the name of the trust, it's not controlled by, if it's not in the box, it's not going to be.
And then what happens if you have a bank account and you have, let's say, your mother, your sister as a beneficiary, and something happens to them and they pass away?
Now that account, if the trust isn't a secondary beneficiary, that account is going to go through probate.
Right.
And the trust is accompanied by a will, right? And why a will? I thought we weren't going through probate. Well, if it's not properly funded, then the beneficiary of your will is your trust. So that one account that had a beneficiary that passed away before you, that account is going to go through probate. And, when the judge sees who is the beneficiary of this estate, it's your trust.
Right.
So now that account is going to be put in the box.
Which is a little confusing because you think a trust, you think it avoids probate, which it does avoid probate, but in our practice, and I don't really know if other attorneys do this, but I've only been practicing with you, but it's good practice to also create a will. And this is different than, it's similar to a last will and testament, but it's called like a pour over will.
Right.
And it's kind of like a safety net to a trust. So if anything is left out, any bank account or investment property, if anything is left out of your trust, it's basically a document that goes through probate. Right. And it just tells the judge, like, you want everything to go into your trust.
That's right. Right. Because if not, then you're dealing with no will probate. That's going to maybe go to different beneficiaries depending on what your trust says. So no, it definitely, trust should be accompanied by that pour over will that you mentioned. That's very important. And we talk about all these little nuances and things that we've seen. That's why I maintain it's so important to talk to an attorney that's seen these documents, that understands how they work. They're not just going to have you sign and go home. We want to make sure that, we're charging the client for a very personalized service, right? And we have that flexibility as a boutique firm. Like, of course, we need to bill our clients, but we don't have billable hours to meet. We don't have the same restrictions. I think they're restrictions that bigger firms have. Like, we can take, it doesn't matter if we spend 3 hours with a client or 15 minutes with a client. It doesn't matter. We have the flexibility to say, look, this client needs these 3 hours because we need to make sure that we are telling them this is the document for you. They want this document. We need to make sure that we deliver on that, right?
Of course, yeah.
Otherwise, what's the point of doing a trust?
Yeah, no, what's the point? Yeah, and every estate plan that we do, we both do it together. We have a whole ceremony, a signing ceremony, and we make sure that everything's included. And I think we spend a lot of time with our clients too. And
we obviously do our best to make sure that this is exactly what they want. It's going to function, but there's always a loose cannon, right? And there are trusts that can be litigated. There are wills that are going to be litigated, and we want to make sure that we've done everything we should have done on our end, right? So if an attorney calls us, we opened the estate for this person and you were the drafting attorney. So tell me, who was there, who made the consultation, who paid for it, we want to make sure we have all of that documented because we want to make sure that we're presenting, we did this correctly. On our end, things did not go wrong.
Yes.
There was a bad actor out there that is causing all this ruckus, but we did everything possible to make sure that we avoided any problems in the future and your document served the way you wanted it.
Of course, yeah.
Right?
Yeah.
But again, things that you wouldn't know if you don't do this every day.
And on that same note, I just want to mention that just because, let's say you have a trust that you did years ago, like my dad, but we won't get into that right now, and your kids are older and you want to name someone else or you want to change the terms, like you can do that with a revocable living trust. Like, You know, we do that all the time. Clients come to us, we will review, you know, an estate plan, a trust, and we'll make comments, and they want to change things. We can always make an amendment or a restated trust. So just because you have a current trust, and if you're listening to this and you're like, maybe I should do this, that, like, there's always ways to, you know, edit that and
absolutely.
update your
And we want to make sure that the trust we create is something that someone that might not have this legal background will understand. Because if you have a trustee that also has to go to an attorney just to like translate this thing, then really what's the point? So I think that is also a benefit of just having somebody who is spending the time to talk to you, like, who is your trustee? What do they mean to you? What's their background?
Yeah.
Right. So we make sure that once it's their time to, you know, take the steering wheel, they know what they're doing.
Yeah.
And they know how to do it. And I think that's very important. Our approach to estate planning is very DIY in the sense that we want to give you this document. We want to teach you how it works. We want to make sure that you know how to update it. We're always here for you. We're a resource for you. We can help you in any way. We can help you do it. But we want you to feel like that, you know, independence. Like, I can do this myself. And I think those clients are the ones that really their documents work without a hitch.
Yeah, and they appreciate it too. You know, they're understanding what they're signing.
Yeah,
it's not like a bunch of legal jargon. I mean, some of it is, you know,
of course,
some they don't understand it, but that's why they hire an attorney. But they know what they're signing, what to do, the next steps. Like, you know, I said it before. Once a client comes in and signs, after we've had numerous calls and whatever, and the documents are perfect, like, it's not like our communication ends.
No, exactly.
Make sure they're funded. I mean, I send weekly annoying email updates like, is your trust funded? Like, is everything in there? So
yeah. And at least once a year, we're checking in and making sure, like, this is still good. This is still what you want. This, you know, and and you said it perfect. The revocable living trust. It's a living document, and we need to make sure that it's living the way you want it.
Definitely.
Cool. Yeah. So thank you so much for joining us here on the Wake podcast. I'm one of your hosts, Alejandra Moreno.
And I'm Taylor Kaufman.
We're from ASM Law Group, preserving what matters most for those who matters most. Thank you.
Thank you.
The Wake is for informational purposes only and does not constitute legal advice. The discussions in this podcast are meant to bring awareness to important issues, but they should not be considered a substitute for professional legal guidance. If you need legal advice tailored to your specific situation, please consult a qualified attorney.